Well, let's get or put all this into proper perspective as we bring in now the head of transfer pricing, PricewaterhouseCoopers, talking about Seun Adu. Thank you for joining us at this time.
Thank you for having me.
From all that has been said now, well, even though it appears not much has been heard about this latest laws, the 2018 regulations, which is said to replace the 2012, let's just, place both on the scale and see what the latter was trying to correct.
So the first thing that clearly comes out when you have a look at the 2018 regulations is that clear intention to ensure enforcement. So that's why you have the penalties, for example. So under the 2012 regulations, you did not have specific penalties per se. Okay. But with the 2018 regulations, they announced specific penalties showing a clear intention from the FIRS to ensure people comply with the regulations. The other thing you find broadly as well is the FIRS is trying to introduce and adopt some of the more recent thinking around transfer pricing in the global space. So they've introduced some of the recommendations from a project that the OECD worked on and released in 2015. They've also included a number of recommendations from the African Tax Administrators Forum, because aside from the OECD project, this organization of African tax authorities also came together to put together rules on transfer pricing that they felt dealt with their own specific African issues. So those are some of the differences you'd find in the 2018 regulations compared to the 2012 regulations.
All right. I guess there's also some worries now about perhaps the old law, or when you leave these companies now to just set prices on their own terms now, there is the possibility of manipulation. Tell us about that.
Yeah, so the concern with transfer pricing and why tax authorities are interested is the fact that when companies that are related to each other have transactions with one another.
That's a group of companies that we know here.
So companies that are part of a multinational group or even a domestic group. Right. When they have transactions with one another, there's a chance that they may not be as diligent as they would normally be if they were dealing with independent parties. Now, the way that affects the tax authorities is the price of those transactions. Say you are selling, for example, the price will influence the amount of sales you recognize. So if you sell at a lower price than you ought to sell, it means you recognize lower sales, and which then leads to lower profits. And because tax is based on profits, it then means that because of that lower price, the tax authorities get a lower amount of tax than they ought to get ordinarily. So that's the primary concern influencing some of these rules and prescriptions around transfer pricing.
And this, FIRS will argue, has implications on the economy and the nation itself.
Yes, potentially. I mean, so because some of the companies that this is targeted at are some of the biggest taxpayers. So if the FIRS has concerns that about whether or not they're declaring the right prices and paying the right amount of tax, the size of their contribution could have an impact on the overall takeaway that FIRS would get from tax.
All right, but now, maybe perhaps a naive person is watching us right now and is saying, okay, a group of companies now. So maybe you should just use an XYD kind of example now to say, okay, perhaps a group of companies now come together and have to determine prices. You want to break that down in simpler terms? Yeah,
so, I mean, a group of companies is really, you have XYZ parent company in the UK. They want to do some business in Nigeria. They could set up a subsidiary in Nigeria to do that business in Nigeria. So if that subsidiary is a company that buys and resells, it's possible that that subsidiary could be buying from XYZ parent in the UK to sell to the market in Nigeria. So it is that price at which they buy from the parent company that is the transfer price. And that is the price that the FIRS is looking to regulate, so to say, or to ensure that that price reflects the market price.
Now FIRS is saying you group of companies engage in what it calls the arm's length principle.
Yes,
Now,
yes.
as if they're not related, so
Yes.
to speak. How would that work?
Yeah, so the idea is they want to ensure that you deal with each other as if the other person was independent, right?
Ideally,
so
they are. After all, a company is independent. Ideally, that should be the norm.
yeah, so so that should be the norm, right? But like I said, when companies are related, there may not be that normal diligence in trying to work out whether that price reflects a market price. So the bottom line is the FIS wants you to ensure that the price at which you're exchanging goods and services reflects the market price. Because if it doesn't, then there's a concern that that price could be manipulated to reduce your taxes. So the other interesting thing that's happened of late is, and you mentioned that at the start, is the public notice. So FIS is giving people 3 months technically to comply with the provisions of the regulations.
Right.
So
I understand.
Yeah.
Sorry, Shio. I understand that the notice came early this month,
Yes.
or perhaps the tail end of September. Early this month. Let's just leave it at that now. Now, tell us. There's somewhat some worry in certain quarters now about if this public notice supersedes the 2018 regulations.
Yeah. So the concern is this: the public notice is asking taxpayers that have not complied in the past with transfer pricing to ensure they do so before December. And if they fail to do so, they will be levied penalties under the new regulations. The concern is this: the compliance requirements for the past years relate to periods that were governed by the old regulations when you did not have the same set of penalties. So the concern is, why are you penalizing them under these new regulations? The other thing that exacerbates that concern is when you look at the new regulations, it suggests that the penalties and some of the other provisions will apply only for future periods, because there's a definition of commencement in that regulation. And it says the regulation is to commence from financial year starting after 12th March 2018. So the expectation for a lot of people was that some of those provisions in the new regulations would only affect them from 2019 going forward. So that is why this public notice is
and now the public notice
shocker.
is now saying all backlogs now should be cleared.
Exactly. So it's saying we're going to apply the penalties if you fail to deal with those past
So
years.
which is binding?
Sorry?
Which of these two, now the public notice and the 2018 regulations, now which is binding on the companies?
I mean, so ideally, clearly, the 2018 regulations should supersede, right? But the question is, it's sort of a question of interpretation, right? So you could look at those regulations and take a view that they will only apply going forward. So it seems FRS has taken a different interpretation. So what this really means is taxpayers need to have a look at themselves and determine if, they need to comply, right? So, I mean, obviously, there's been that requirement to do some of these things in the past. So it makes sense for them to try and comply and avoid that dispute altogether. If, however, for any reason, they are not able to comply with this, December deadline, then they may need to consider what legal options are available to them.
And then there's also the issue of the level of engagement between the tax agency in Nigeria and the domestic groups. To start with, the domestic groups, talk less of, the international group of companies. How sufficient is this, especially to clear these gray areas?
So I think what has happened is not everybody has a lot of visibility around what is going on from a transfer pricing perspective. So there seems to be an assumption, particularly within domestic groups, that transfer pricing is the headache of multinational groups. So unfortunately, the Nigerian regulations cover both multinational groups and domestic groups. So it's really important for domestic groups to bear this in mind, so that they don't unknowingly run foul of the regulations and expose themselves to penalties.
Okay, but another thing again is the agency itself, the
Yes.
FIRS now, the agency, there's also the issue of will the agency act in good faith? I mean, we're talking about tax.
Yeah.
Many people run foul, many companies run foul of taxation, many people also run foul of taxation. And then there's also the allegations that perhaps the agency may not be acting in good faith. The issue of multiple taxation too has also been raised in certain quarters now. How do you think this would apply to FIRS moving forward?
Yeah. So the expectation is that in applying the regulations, because there's some provisions that require discretion, and the principle in law is that where a regulator is supposed to apply discretion, that should be applied in good faith. So the expectation is that that will happen. And to be fair to the FRS, what they've tried to do of late is to try to be very clear about their intentions. So for example, they're saying people have 3 months. They've also tried to be very clear about circumstances under which they will give people extensions. So one of the things that was included in the TP documentation guide that they recently released was the conditions under which they would grant extensions. And by extension, what I mean is, if you're required to submit something to the FRS, there could be circumstances where, for whatever reason, you can't meet up with the deadline that has been prescribed. So what people would normally do is write to the FRS and try to get an extension. So what hasn't always been completely clear is the circumstances under which you'll be eligible for that extension. So they've also come out to say, look, this is the criteria we'd use to assess your extension request, so that if you are going to make a request, you need to actually check whether you meet that criteria. So in a sense, that's them trying to be open about what their plans are. But I also think it's also a clear indication that they will be a lot stricter about granting extensions going forward, because there's a general drive to ensure that people take the tax regulations seriously and they take steps to comply as required by the law. And
talking about strict, you've mentioned, the FIRS is being strict, is also being clear. But talking about the strict terms now, one would also argue that perhaps, these regulations are a bit far-reaching. Would that be fair?
Yeah, so there are a number of provisions in the regulations that are quite contentious, if I would say that. Okay. So for example, there's one provision in the regulation that says the FIRS will not be bound by the value for customs purposes. So basically, if you are the person that imports goods from related parties to sell in Nigeria, you would have paid customs duty. Customs would have placed a value on those goods. And the FIRS is saying, look, we will not necessarily follow the valuation used by customs. We will do our own independent transfer pricing analysis and determine the value of those goods. So what this could potentially lead to is double taxation, because you have two governments, authorities, regulators, who will either directly or indirectly levy you to tax based on the value of those goods. And both of them are saying we can, use different prices. So that's an example of one of the contentious areas, because that puts taxpayers in a situation where they could potentially be exposed to double taxation.
Sure, there's also this worry about royalties, which subsidiary companies, for example, here in Nigeria, have to pay to the parent companies abroad. Yeah. How is the tax agency, dealing with that?
Yeah, so the concern with regards to royalties is the new regulations try to place a cap on royalties that are payable by subsidiaries to their related parties abroad. And that cap is a fixed percentage of EBITDA. So it's what accountants call earnings before interest, tax, depreciation, amortization. The concern with that is it doesn't necessarily reflect the arm's length principle, because in reality, the transfer pricing regulations should be reflecting the arm's length principle. So normally when independent parties transact with one another, it's not common to find royalties being capped to EBITDA. So royalties will typically be a percentage of sales depending on the value of the intellectual property that you're using and the type of intellectual property that you're using. So that provision is contentious because it's not, I mean, it's not consistent with international standards on transfer pricing, and it seems to be a more Africa-centric approach to dealing with transfer pricing issues relating to royalties.
All right, interesting, Seun Adu there. We thank you for explaining all this, breaking it down to us. Seun Adu, of course, is the head of transfer pricing of from PricewaterhouseCoopers. Thanks again for speaking with us.